In our final section, we will take a look at a brief overview of the basic role of long-term care facility staff who are caring for a resident who has a power of attorney and a resident representative. To aid our consideration, let's consider the admission of a new resident, Fran, who is 71, and the mother of daughter Terry. Terry advises that her mother has lived with her for the past several years, and during that time she has cared for her and handled her finances. Terry also advises that her mother has a power of attorney that appoints her as her mother's resident representative. That was the first step. Well, all long-term care facilities must determine and document in the resident's record the resident's cognitive capacity, whether the resident has a guardian, a power of attorney, or any other type of advanced directives, and who has the authority to make healthcare decisions. So the first step would be to request a copy of the power of attorney. And a photocopy or electronically transmitted copy would have the same effect as the original document for your records. And what if the resident does not have a power of attorney? A facility's responsibility is to obtain a copy of an existing power of attorney. It is not the facility's obligation to require that the resident execute one if there is not one already in existence. And while it is prudent for the resident to have a current power of attorney, the facility should encourage the resident to have one, of course. And it is solely the resident's choice to have one or not to have one. And here we must consider another change in law that took effect on January 1, 2017. And once again, I caution you that the change may appear complicated in this brief presentation, and recommend that you take the time to review the information that is in your available reference guide. For any power of attorney that is executed on or after January 1, 2017, a facility must accept that power of attorney no later than 7 business days after it is presented, or the facility must request a written certification from the resident representative. We will discuss certifications presently, but if one is requested and then received, the facility must accept the power of attorney no later than 5 business days after it receives the certification from the resident representative. And I'll just point out here that the same rule applies to any requests that a facility may make for the translation of a power of attorney. These rules do not apply to any power of attorney that was executed before January 1, 2017. Although the law before that date allowed for written certifications by the resident representative, they were not subject to any mandatory timelines. So why the change in law? What is the purpose of a resident representative certification, and why would you ever request one? Residents ordinarily have powers of attorney that appoint a representative, and rarely is there the need to question either the validity of the power of attorney or a resident representative's authority. However, should the need arise, the law now permits a facility to request a written certification from the resident's representative. And let's be clear, the request is made to the representative and not the resident, as it is the representative who will be required to provide the written certification. Just what is a resident representative certification? Well, first, it's in writing and made under the penalties of perjury, so it must be truthful, at least to the extent the representative knows the facts at the time the certification is made. Essentially, the certification must state that the power of attorney and the representative's authority under it are valid. And what this means is that in the certification, the representative affirms the appointment as resident representative, that the resident had capacity at the time the power of attorney was executed, that the resident executed it, power of attorney without any undue pressure or coercion, and that the representative has no knowledge of any facts or other circumstances that would indicate that either the power of attorney or the representative's authority is void, invalid, modified, or terminated. The legislature has provided a convenient form that the representative may use to provide the certification, and additional information about the form can be found in your reference guide. What benefit does the certification provide? Well, one benefit is that no further investigation of the validity of either the power of attorney or the representative's authority is required. However, any reliance on that certification would not be available if the facility has any knowledge or of any information that contradicts any of the statements made by the representative in the certification. Finally, we should note that there are potential penalties for refusing to accept the resident representative's certification. First, let's recall that the change in law regarding a representative certification applies only to powers of attorney that are executed on or after January 1, 2017. With that in mind, be advised that the new law allows the resident or a representative to bring a court action to obtain an order that may determine the refusal is unjustified, requires the facility to accept the power of attorney, and also reimburse the resident or the representative's court-related fees and costs. This last point may provide a powerful incentive for a resident or representative to go to court. And some final points about resident representative certifications. Although the law has always provided for them, this is an entirely new treatment, and it remains to be seen how they can be effectively requested and used. Facility administrators may choose to exercise their discretion to seek legal advice regarding the decision to request a representative's written certification. Once a power of attorney has been presented and accepted by the facility, time should be taken to read and review the power of attorney to find out some very basic but also quite important information. How is the power of attorney executed? Is it currently in effect, or will it take effect on a future date? How and when does the power of attorney terminate? Who is the resident's representative? What authority does that representative have? Is there a co-representative, a successor representative? What authority were they given? In answering these questions, you should be applying the information that was discussed in sections 2 and 3 of this presentation. Now let's take a look at the importance of knowing when you may rely on a resident representative's decision-making authority. When is it appropriate for the facility to rely on a resident representative's decision-making authority? Obviously, it would be appropriate when the resident with capacity confirms the authority of the representative. It would also be appropriate when the facility has no actual knowledge that the power of attorney was not properly executed by the resident, or the power of attorney of the representative's authority is void, invalid, revoked, or terminated, or the resident representative is exceeding the scope of authority provided by the power of attorney. When would it be justified to refuse to accept the power of attorney or representative's authority? Once again, we must refer to the recent change in the law. For any power of attorney executed on or after January 1, 2017, it would be justified to refuse to accept the power of attorney or the representative's authority when the facility has actual knowledge that the power of attorney or the representative's authority is terminated, or has a good faith to believe that the power of attorney is invalid or the resident representative does not have authority, regardless of any certification that the representative has provided stating otherwise. When the facility has actual knowledge that a report has been made to Adult Protective Services or the Department of Social and Health Services based on a good faith belief of abuse and neglect, exploitation, or abandonment by either the representative or a person acting for the representative. Whenever a request for a representative's certification or a translation of the power of attorney is refused, and whenever the facility would be unable to perform any particular service that is requested for the resident, or the performance of that service would violate federal law. Now, although powers of attorney that were executed before January 1, 2017 are not explicitly covered by this new law, those reasons would also make sense when dealing with one of those prior powers of attorney. Regardless, please take care to note that a facility would not be justified in refusing to accept the power of attorney or a representative's decision solely because the facility disagrees with the decision made by either the resident or the representative. Of course, facility administrators may choose to exercise discretion to seek legal advice in situations where either the validity of a power of attorney or the representative's authority may be in question. With all this in mind, let's revisit our resident Fran and her daughter Terry and consider two situations. In the first one, there's been a change in her mother's condition. She has been falling and seems confused about how to prevent them. The facility wishes to schedule a care conference to discuss the situation. And the daughter Terry is not inclined to have her mother attend. She feels that it would just confuse or upset her. And she makes all the decisions anyway under the power of attorney, similar to when her mother lived with her. In the second situation, the daughter Terry calls to inform the facility that her brother Philip has recently moved back to Washington, contacted her, and wants to visit their mother. She demands that the facility not allow her brother any access to their mother and wants the facility to notify her immediately of any attempt by Philip to visit or contact Fran. How should the facility handle the daughter's requests and directives? We have previously reviewed the resident's representative's responsibility as to when it is appropriate, not appropriate to rely on their authority. Let's consider some of the facility's responsibilities in these two situations. Let's remind ourselves that all long-term care facilities are required to comply with the rights granted to residents by Washington's Residents' Rights Law and the laws and regulations governing each type of facility. Consistent with this obligation, a long-term care facility must ensure that a resident's representative is able to participate in resident-related decision-making. And observe that the resident representative acts consistent with the authority that has been given by the power of attorney and is supportive of the resident's rights as guaranteed by law. Additionally, a long-term care facility consistent with resident rights laws has an independent obligation to promote a resident's right to participate in all decision-making to the maximum extent that a resident is willing and capable. And this is so even where the resident may have a resident representative appointed by a power of attorney. Let's also recall that a power of attorney does not require a resident to surrender independent decision-making authority, and that the representative has the obligation, regardless of the resident's capacity, and consistent with the resident rights law, to act to support the resident's reasonable expectations if they're known, and where they're unknown or cannot be determined, to act in the resident's best interests. And finally, don't forget the facility has an independent obligation to promote a resident's right to participate and be fully involved in all decisions regarding care and continued residence to the extent that the resident is willing and capable. Let's take a brief look at some of the resident rights we've referred to, which include the right to participate in planning, care, and treatment, to direct their own service plan and changes the same, to receive and refuse any particular service, to choose activities, schedules, and health care consistent with interests and care plans, to privacy and communications inside and outside the facility, visits from family, friends, and others, access to physicians, state representatives, advocates, and the long-term care ombuds, as well as freedom of physical and chemical restraints, verbal, sexual, and mental abuse, corporal punishment, involuntary seclusion, or isolation. In the event that the long-term care facility staff believes that a resident's representative is not exercising appropriate authority on behalf of a resident, or has any grounds to refuse to accept the resident's representative's authority, or has any knowledge of suspected actual abuse, neglect, exploitation, or abandonment by a representative or a person acting for that representative, the facility should take appropriate actions to ensure that residents' rights are protected. Administrators may exercise their discretion to seek legal advice regarding the residents' rights and the facility's duties and obligations to promote and ensure compliance with them. The local long-term care ombuds is also knowledgeable about resident rights, law and is available to provide information and support for a resident. And so with respect to the daughter's desire to exclude her mother from the planned care conference to discuss a plan to deal with Fran's propensity for falling, Fran may be evidencing difficulties handling a situation, but the basis for that difficulty must be determined, and Fran's input is likely a critical part of that process. Further, her point of view on participation is currently unknown. The representative may not simply exclude her from any discussion with facility staff about her present situation and the steps that can be taken to address it. It is the responsibility of both the daughter as resident representative and the facility to ensure the resident is provided the ability to participate to the extent that she is desirous and capable. Similarly, with respect to the daughter's request that the facility bar her brother's ability to communicate or visit with his mother, Fran's desires and choices must be respected. As a resident, she is entitled to visits from and communication with persons of her choosing. As an aside, the Washington State Legislature obviously attaches great importance to an individual's right to have communication and visits with persons of their own choosing. It has recently rendered the law to require court-appointed guardians to first obtain either a vulnerable adult protection order or an amended guardianship order to restrict a resident's ability to receive visits from or communicate with persons of their choice. And so the daughter as resident representative may not simply block her mother Fran's ability to receive visits from or communications with her son. She must be provided the ability to visit and communicate with Philip to the extent she is desirous and capable. If there is an issue of actual or suspected abuse, exploitation, the appropriate authority should be contacted. And remember, long-term care facility staff members have an independent obligation as a mandatory reporter. Should the facts and circumstances warrant, a petition may be made to seek court intervention. A petition to the court may be filed by a resident representative, or a person asked to serve as a representative, a spouse, state registered domestic partner, guardian, or other interested person. And here is where a facility can act. However, the court must be satisfied that the interested person is interested in the resident's welfare, has a good faith belief that the court intervention is necessary, and that the resident is incapacitated and unable to protect her interests at the time of filing. What remedies can the court provide? The court has broad powers to intervene and provide effective remedies, which may include the following. It can determine the status of a power of attorney or modify it, ratify past or pending resident representative acts, or order the representative to not take action. It can remove the representative for the violation of fiduciary duties or in the best interests of that resident. It can compel the representative to report or submit accounts. It can confirm the authority of a successor representative. It can compel the facility's acceptance of a power of attorney and to honor the representative's authority. Additionally, the court may award attorney's fees to the prevailing party, that is the party that succeeds at court, if the validity of a power of attorney is confirmed or the acceptance of a POA is mandated, and in its discretion in all of the circumstances. Once again, facility administrators may choose to seek to exercise their discretion to seek legal advice regarding the need to obtain formal court oversight. And finally, long-term care facility staff are reminded that they are mandated reporters and must report to the appropriate authorities any instances of actual or suspected abuse, neglect, exploitation, or abandonment by a resident representative or a person acting for that representative.